Okay, 3 minutes granted. Counselor, you're on.
Very much, Your Honor. May it please the court. Defendant, now 24 years old, has been convicted of aggravated criminally negligent homicide, a Class E felony, for causing the death of a state trooper who lost control of his SUV, ran off the road, and into a tree. The defendant is serving a 7-year sentence. The immediate question arises, Your Honor, how can the conduct of the defendant in being followed at a third of a mile or more by the state trooper in the SUV have caused the state trooper to lose control of the SUV in attempting to take a 25-mile-per-hour speed control curve at 90 miles per hour or more?
Counselor, how would you describe the conduct of the defendant during this, where the trooper was following him? How was he driving, or at least in your view of it?
There is evidence that this unquestionably was a high-speed pursuit. There's no question about that. There's evidence that the defendant was going at a high speed, that he did weave in and out.
Did he speed up? Did he speed up when the trooper was following him?
I believe that that's correct. I believe he did, Your Honor. And that raises a very, very important point in the case, because this was a traffic speed pursuit. And under the police pursuit policy, state police pursuit policy, when the immediate apprehension of a speeder or of someone they're trying to take into custody is outweighed by the danger to the public by pursuing and continuing the pursuit under the policy of the state police, that pursuit must be terminated. So what caused the danger here was the pursuit itself.
Well, how is this different from DaCosta? Why doesn't DaCosta control this case?
DaCosta is different in a very critical respect, Your Honor. In DaCosta, the police officer was doing what he had to do. He was bound to try to take the escaping criminal into custody and tried to get across the 6-lane high-speed highway, and in doing so, trying to get over a fence in the median, fell into traffic. Here, the state trooper chose. It was his choice to continue to attempt to arrest a speeding violator in violation.
In DaCosta, though, the defendant put in motion the foot chase across the highway. Don't we have a defendant here that also put into motion the need for this officer to try to follow him?
True, Your Honor. That is absolutely true. But what has to be shown here for the possible causal connection is much more than just putting it into play. What has to be shown under Matos and DaCosta is that the causal connection was sufficiently direct. It may not be obscure or merely probable, and sufficiently direct requires that
And the accident here wasn't more foreseeable than the officer falling over the fence in DaCosta?
Exactly so. It certainly was not. What would have to be foreseen here under the third element of DaCosta and Matos is that the result, in this case, the death of the state trooper hitting a tree, would have to have been reasonably foreseen. So that means that in driving this motorcycle and being pursued, it would have to have been reasonably foreseen that the state trooper, third of a mile behind, would choose not to terminate, which he should have done.
Well, your client obviously did foresee that the police officer would keep chasing him. I mean, your client wouldn't have been speeding if he didn't think he was being chased.
That is true, Your Honor. He knew that he was being pursued. However, he would have to have reasonably foreseen that the state trooper would choose not would continue and would choose to try to take this 25 mile per hour control curve at 90 miles per hour or more.
What would defendant have thought was going to happen here? That the trooper should it have been, and the defendant said that he's really not supposed to keep following me and he's going to terminate? What would he have foreseen what was happening here? That either he would outrace him or the trooper would go away?
Your Honor, I don't know what the defendant himself would have foreseen.
Or should have foreseen.
Or should have foreseen. But the test is not what the individual would have foreseen. The test is what is reasonably foreseen.
What should he have reasonably foreseen?
But what, under the circumstances, would it have been reasonably foreseen that the state trooper would violate the pursuit policy, would violate 1104E, and for heaven's sakes try to take this 25 mile per hour curve at 90 miles per hour or more in an SUV which is known to be unstable?
Do we end up with a rule that the faster you flee from the police, the less your liability is?
I'm sorry, Your Honor.
Do we end up with a rule that seems to support a concept that the faster you flee from the police, the less your liability is? Because the officer becomes more responsible?
Not at all, Your Honor. I think what the officer has to do is to conduct a pursuit in accordance with the dictates of the policy. One of the dictates is that you have to analyze what is the purpose of trying to apprehend the speeder. What good will come, if any good that might come of that is outweighed by the danger of continuing? You have to terminate.
Wouldn't you then say that DaCosta's wrongly decided too, on that standard? Wouldn't DaCosta be wrongly decided as well? I mean, there you had a police officer who ran across the major artery out of Buffalo in the middle of rush hour on foot.
I don't believe so, Your Honor, because in DaCosta, unlike the case here, and just as in Matos, when the police officer was trying to take into custody an escaping criminal who went across a darkened roof at 4 a.m. in the morning, fell into a hole, in DaCosta and in Matos both, the police officers had to do what they were doing. They had no choice. There's no claim in DaCosta, no claim in Matos that there was any contributory negligence, no claim that the policemen in those cases didn't exercise due care for their own safety. This is unlike this case here, where you have a third of a mile between the motorcycle and the following defendant. And unlike this case here, as soon as the police was, the defendant went over Route 20 and down the hill, he downshifted. Once the chase stopped, the danger which is produced by continuing the chase disappears.
Would you make a distinction then about the seriousness of the I don't want to say the crime charged because there's nothing charged yet, but this was a speeder, right? At the time that this all happened, the only reason the defendant was being pursued was because he was speeding.
Definitely the defendant was speeding.
So if that's all that we're trying to do is stop a speeder.
I think that's true. That's all. This was a traffic violation, speeding violation, and that was the purpose of it. And that's one of the very important factors in deciding under the policy, state policy, whether even to start a pursuit. What could have been done here is call in, and they would have gotten somebody else to stop.
Counsel, but once he starts following him, what does the trooper make of the fact that you see someone speeding? The normal speeder would, when you have a police officer following, would slow down and stop. What does the police officer make of the situation when in this case, the defendant on the motorcycle speeds up? Does that say to him that there's more than a speeder involved, or?
I don't think that it does, Your Honor. I think in a case of that kind, the trooper is supposed to exercise judgment as to whether it's worth continuing this pursuit or whether he should call his supervisor and have them pick the speeder up. That's what the police policy says.
The bottom line of your contention is that the police officer exercised bad judgment in this.
He did. There's no question about that. I'm not saying he was the total cause of it, by no means, but he was a substantial cause of the tragedy that followed.
Well, that was going to be my question. Assuming that the police officer exercised bad judgment, the defendant also, by speeding ahead and starting the chase, he may also have caused part of the police officer's injury, right? And you don't have to be the sole cause of it.
Unquestionably, the defendant used bad judgment in speeding. There's absolutely no question about that. But
and ultimately, he was charged with reckless driving, along with the aggravated criminal negligent homicide, right? He was charged with reckless driving, ultimately.
I'm sorry.
He was charged with reckless driving. Ultimately.
Yes, he was, and that's what he was guilty of. There's no question about that. But if I may,
Yeah, sure. Go ahead.
Go on to one other.
Sure.
I'd like, at some point, could you address the replacement of counsel issue, the lawyer issue, the issue relating to whether his lawyer was properly replaced? Could you address that at some point?
Yes, I will address that right now. There's absolutely no question, Your Honor, that the lawyer who was retained, Mr. Majesto, was discharged in violation of the defendant's Sixth Amendment and constitutional rights in Article 1, Section 6 of the New York State Constitution. He was deprived of his constitutional right to counsel of his choice. The reason for this, stated by the trial court, was that there was supposedly an absolute conflict which could not be waived.
Well, there was a possible conflict, right? Because the lawyer had represented the girlfriend and her father. So there was a possibility that they testified in the grand jury. He had represented them in the grand jury. There was a possibility that they would testify at trial. So there was a possible prospective conflict here, right?
Yes, I think that's absolutely correct, Your Honor. At the very first part of the motion, which was made by the district attorney, and which, by the way, said it was a potential conflict. There was nothing about an absolute conflict in the district attorney's motion. But you're absolutely right. It was a potential conflict at that time.
So what's the judge supposed to do? What's the judge supposed to do when confronted with that?
I'm sorry.
What's the judge supposed to do when confronted with that?
When he's confronted with something like that, what the judge is supposed to do is to determine whether or not the conflict is a serious conflict, whether or not it's something that should be waived. There's absolutely no question.
The judge is not bound by the defendant's waiver on this issue, right?
I
mean, under Wheaton, the U.S. Supreme Court cases, the judge can use their judgment in balancing his right to choose and protecting him for his own good.
But Your Honors, the judge is bound to pay attention to the waiver of the defendant.
Yeah. But he's not bound by it, right?
It's a defendant's choice. It isn't the court's choice.
No, but am I correct that these two witnesses did testify in front of the grand jury?
They did.
So, I mean, it wasn't that unreasonable for the judge to be concerned that they might also take the stand in this case, correct?
At that time, he certainly should have inquired into it, and he did, and he was told at the very first meeting, several colloquies, that it might well turn out, as it did turn out, that there would never be a conflict.
I mean, I understand in hindsight we don't have a conflict, but I'm not so sure that the judge was that confident it wasn't going to arise before trial.
Well, I see that.
Answer, sure, Captain. Answer the question.
If I may finish
Sure.
the sentence.
Yeah.
Under United States against Perez and cases that are cited in that decision, a conflict which may develop in the future, and that's what this case is, one which may develop, is a waivable conflict. And under Perez, it's a very, very narrow range of conflict situations which are not waivable. And this is a minor thing, never would have developed into anything serious. And
Is there any indication in the record that in these witnesses there were the father and the girlfriend were potential prosecution witnesses? Is there any indication that they were actually antagonistic to the defendant, or did they want to help him?
there was never any indication that they were antagonistic to the defendant. What the testimony.
I guess what I'm getting at is, even if you assume that they did testify, that they were good, that the prosecution would have called them to testify, is there really a conflict when the prosecution decides to call your father and your attorney has represented the father? Isn't the conflict more theoretical than real there?
Even in that case, if that did arise, it still could have been waived, because. But, of course, that's assuming something just contrary to what happened, because at the time this all went on, the colloquy went on, it wasn't known what the facts of the case were. It wasn't known what the tactics of the defense would be. And
wasn't there some indication, though, that one of that it might be that the defense would say that he was not the driver of the motorcycle? Was there any indication of that?
I don't think at that point. I think it was up in the air because the investigation had just started. This was shortly after the accident occurred. And, of course, as it developed, he gave a statement to the police, which is in evidence, saying, of course, that he was the driver. There was no question about that. And that quickly developed. It developed as defense counsel said to the court, look, there's no clear evidence that these witnesses are ever going to have to testify. They may well not, and there may not ever be any conflict, and that's the way it turned out.
Okay, counsel, thank you. Now, your adversary, then you'll have rebuttal.
Good afternoon.
Counselor, go ahead, proceed.
If you would allow me, I'd like to address the conflict issue first
Yeah,
and then
please
the
do.
sufficiency.
Go ahead.
I'd want to ask you to look at it first from the standpoint of the judge at the time this was being first discussed before trial, and then I want to discuss it as the trial actually happened.
Okay.
From the perspective of what the judge was looking at before the trial started, we had two witnesses, the defendant's father and the defendant's girlfriend, who we had called before the grand jury. They showed up with counsel, and that raised the flag for us that we felt we had to bring it to the judge to get the judge to make the inquiry.
You didn't say to the judge this is an unwaivable conflict, did you?
No. We asked the judge, and the judge did what we asked, which is to look into it. And the judge looked into it. And he did not accept the defendant's waiver. And under People v. Wheat, the case you mentioned, Supreme Court, that is within his discretion.
But it is a narrow window, though. I mean, the judge, the whole purpose of doing this is to ensure that defendant's rights are not compromised. So when the defendant waives, it does put this into the judge really has to be looking at, what can go through that window, saying, well, you waived, but, that's not good enough, right?
Yes, but
often the judge would just accept that waiver in normal situations.
often they would. But
What would have been the harm of accepting the waiver here?
two things come to mind. Keeping in mind that if we had counsel continue, we could be hearing today, my defense was compromised, the judge should never have accepted my waiver.
That's what bothers me. I'm having trouble seeing how he could, no doubt someone would make it, but how could you argue with a straight face, my defense was compromised on these facts in this case because my lawyer was inhibited in tearing my father apart on the stand? I just don't see it.
Well, let me take you through an example, Judge, or a possibility. Sometimes witnesses say different things at trial than they said in advance of trial. And if you, for example, take the girlfriend who initially told the police she didn't know anything about it, and then she came around and said, well, yes, he did make these statements to me. By the time the trial comes around, she's back to her first statement, and she's backing off her grand jury testimony. Gee, Your Honor, I guess I need a lawyer. Who's your lawyer? Oh, they're sitting over there with the defendant.
Have you ever seen that happen?
No, and it's a good thing we don't have it happen.
At this point, the one sitting with the defendant is her former lawyer.
Well,
and couldn't she at least be asked if she's willing to waive whatever rights she has to retain? I mean, isn't it overwhelmingly likely that all three of these people would have said it's just fine, keep the lawyer, I'm not worrying about any conflicts?
well, perhaps, Judge, but on this record, that did not happen.
Well, it didn't happen because the judge refused to accept the waiver.
Well, but in the discussions before that judge made that decision, the defense could have said, and we no longer represent them, and they're waiving this.
Is the record that he still did represent them? Well, did they need a lawyer at that point? Did they have any exposure?
The girlfriend's exposure would have probably been limited to whether she, in that example I gave a minute ago, gone back against her testimony to the grand jury and would have been subject to possible perjury.
You're the one trying to show an unwaivable conflict. Why wasn't it the people's burden to say, well, we've got this terrible problem here, this woman is going to need a lawyer, you better get her to waive?
Well, Judge, I would submit that under the case law, it's both sides' obligation to bring it to the attention of the trial court.
But isn't the presumption that the defendant gets the lawyer he wants unless there's a very strong showing that it's going to taint the trial?
Well, I think the presumption also should be that the trial court, as a matter of policy and as a matter of law, has to have discretion here.
Why was it? I'm sorry, Judge Pickett.
What was the point of appointing independent counsel if, after appointing independent counsel, and she comes back and says he understands, he's been told all of the possibilities, and he is willing to waive any possible conflict? Why was she even necessary?
I think, Judge, that the trial judge was trying to accomplish two things, like a checkoff list. He had to make sure, if he was going to let counsel continue, that the defendant made a knowing waiver of that. And that's where the Attorney Campbell came in.
And she said he is.
And she said he is. She didn't say he opposes substitution of counsel. She says he's willing to waive it. Okay. And
she believed the defendant understood the risk of keeping these lawyers of counsel, and that they're willing keep the counsel.
Yeah. That's part of the analysis that if he had kept them in the case, that would have been important.
It kind of goes back to what Judge Smith said. So now you've got the court surprised him of all of his rights and remedies here. He says, I want this lawyer. I'm going to appoint another lawyer to look at you. The other lawyer goes out and looks and says, he's aware, he wants to keep the lawyer. The judge says, I thought that's what he was going to say. I'm saying he's got to get a new lawyer.
All right.
What's the basis upon which the judge made that decision, I guess, is what I'm asking.
I think, just to back up for a second, Judge, I think the judge was hoping to get off the hook. If the defendant came in and said, okay, I'm not going to waive, then he doesn't have to make a difficult decision.
Right.
But he did have to make the difficult decision. He had to exercise his discretion, and he's looking at a trial where you could have witnesses on the stand represented by the same attorney who's representing the defendant. How do
But
you...
in light of the relationship between those witnesses and the defendant, was it reasonable, was it an abuse of discretion for the judge to do what?
It was not an abuse of discretion as a matter of law.
Even in light of the relationship that it's the father and the girlfriend?
Yes, Your Honor.
Because what strikes me is obviously even if there was a different lawyer, I mean, they're going to talk. I mean, he's going to talk to his father, he's going to talk to his girlfriend. I mean, the story is going to be what they ultimately expect it to be. And I couldn't help but analogize this as I was reading your brief to jury selection. You know, when a defendant says, I can't get a fair trial, I want to move the trial. And at least the Fourth Department, as you know probably better than I, we say try. Pick the jury. You know, if you come back and say you can't get it, fine. Why wouldn't that have, I think I'm leading into what you said, what happened at the trial. What would have been wrong to say, Mr. Defendant, you know, you've been given every opportunity not to have this lawyer. You're keeping this lawyer. And so he keeps the lawyer, and then if something pops up later, handle it then. What would have been the problem?
Well, the problem with that is we could be going through jury selection and a trial, maybe most of a trial.
But you knew at some point you weren't going to call them anymore.
Well, we knew that when we rested. We had them on our witness list, and what they say in the sports world, a game day decision. We had to decide, and it was a risk because they were aligned with the defendant. We had to decide whether to call them.
Isn't there also a risk, and I see no indication that that happened here, but isn't there also a risk that a decision like this is an invitation to the prosecutor to put people on it to have a rather expansive witness list? There are prosecutors in the world who are quite capable of putting the defendant's father and girlfriend on the witness list just for gamesmanship purposes. I really do not. Having looked at this record, I don't think that happened here. But don't you create that risk by this kind of ruling?
If that happens in another case, I would imagine this Court would not approve of that. But here we had two people who the defendant told things to, which were important information, would have been vital information had the defendant's confession been suppressed, or statements been suppressed. And so I think that this, though you may have that concern.
Are you asking us to make a per se rule that if there is someone reasonably likely to be called as a prosecution witness who has been represented by the defendant's lawyer, that the judge can always disqualify the defendant's lawyer?
No. What I'm asking you to say is that when that happens, the trial court has to use its discretion.
Well, aren't you really saying that in that case, if he exercises discretion to disqualify, it's never an abuse?
Yes.
So he can really, you're really giving him carte blanche, aren't you?
Well, I think the Supreme Court has done that as well from Wheat, where they said that a district court must be allowed substantial latitude in refusing waivers of conflicts of interest, not only in those rare cases where an actual conflict may be demonstrated before trial, but in the more common cases where a potential for conflict exists.
But aren't
which
those common cases? Most of those common cases are drug dealers stabbing each other in the back, basically. I'm testifying against you. You're testifying against me. I was in it with you. I wasn't in it. It's a very here we have people who really are united in interest and very likely to stay that way. Isn't that a much weaker case for disqualification?
Yes.
When would it be an abuse? What would be an example of where it is abusive? In this kind of situation where there are potential witnesses?
I don't – nothing leaps to mind, Judge, but I would think the defense would have to show much more than they showed here. The defense here pretty much came up with, well, let's go to trial and see what happens. And I think the judge exercised discretion properly in deciding not to do that, to the point of he was prescient in that if you look at what happened at trial.
But what happened later is irrelevant. I mean, he couldn't have known that that was going to happen, right?
I don't think it's – I think it's extremely relevant in the sense –
Do you think it's relevant?
Here's why, Judge.
Yeah.
At the time this was being discussed, the judge and we didn't know that the defense counsel was on the phone with one of our witnesses. But the lawyer knew that and didn't have an investigator interview the witnesses, but became a witness in the case.
So you're saying this is part of the judge's thinking when he made this decision? That's
No.
not what you're saying. Right?
No. His thinking was, gee, this could be a real problem. What if the attorney knows something from these clients and he has to become a witness advocate or a unsworn witness and saying in cross-examining a witness, isn't it true you told me X or Y? Similar situation actually happened with the prosecution.
But the bottom line is you can't think of a case in this general situation where it would be an abuse of discretion for the judge to not accept the waiver.
I mean, it would be abuse of discretion if there was no basis for it, but here there was a basis for it. And the way the trial –
So whenever there are potential witnesses, it would not be an abuse of discretion. I mean, that's not a rhetorical question.
No, I think you could –
Under Wheat and all of the cases along this line, there are potential witnesses, waiver or no waiver, regardless of the relationship between the witnesses and the defendant, it's never an abuse.
I say that, Judge. And again, I don't want to belabor it, but I do think it is extreme.
That's the rule in your mind, though. Yeah.
That it's within the
That's
judge's
what I'm
discretion.
asking.
Oh, yes.
I suppose if you had multiple witnesses that heard a conversation such that other people could testify to the same information, it would be cumulative, that might be an abuse of discretion, to use that as a basis.
Right. And that's not – certainly that's not what we had with the – Leslie Sisto was our witness who he – the very first witness for the defense was the counsel who had been removed, who had had a telephone conversation with Leslie Sisto. And I don't mean to digress, but there's just one thing that I want to convey, and that is in the briefs, and there seems to be a thinking that it would have been okay because identity was conceded. Well, identity and knowledge that he was being followed was something we proved, and we were able to prove without calling those witnesses, but it was far from being conceded.
Well, once you had his statements in, wasn't that taken care of?
To my mind, in the jury's mind, it was, but
I mean, once the suppression had been denied on those, you kind of knew the identity wasn't going to be a problem.
But he still pled not guilty. We still had to prove it. And just let me take it one step further, had he been convicted with the conflicted attorney, he might very well have been up on appeal saying, that attorney sold me out. He didn't contest that it was me on the motorcycle. The attorney he did have that was not conflicted, if you look at his summation, page 1818, attacks the video evidence the DA will argue shows identity of the individual on the bike, the motorcycle. 1819, reminds the jury that the DA has to establish identity. 1820, says that he'd be remiss in his obligation to defendant if he didn't suggest to the jury that we just quite don't know. Now, it's not a great argument, but it's an argument, and if it hadn't been made, we could be on appeal saying
You have an ineffective assistance of counsel claim here also.
we do not.
We don't? Not in this case?
They don't make one.
Oh, okay.
I'm sorry, Judge. They make one in kind of a offhanded way in the sense that they're saying, I guess, that the lawyer who was conflicted and was removed would have maybe done better than the lawyer they had.
Well, wasn't there, what about the incriminating statement
Yeah,
that
the
he
one let him
makes?
talk to the police.
On the advice of counsel is what Judge Barrett's talking about.
Excuse me. I was thinking you were talking about an argument that the actual trial counsel was ineffective. So you're talking about the initial Mr. Savlov.
Yeah, so
Okay,
what about that? And had the attorney-client kicked in at this point? Was there a relationship? And was that ineffective assistance of counsel?
No, it wasn't, because I have two arguments on this score. One is that when the attorney was told that they have evidence against the client and that the prosecution would consider on sentencing and in negotiating any cooperation statements, which we ultimately did do. It didn't work out. Obviously, the case went to trial. But that there was a quid pro quo, that the attorney gave good advice. I have another.
Turned out it probably wasn't very good advice, right?
Well, if he had followed it and continued along, he may be concluding his sentence sooner than he'll ultimately do that if you affirm. So it's a matter of tactics, and it's a matter of judgment and deciding which way he wanted to go. He decided to go another way.
It was ineffective. Do you contest the fact that we could, that it could be suppressed? That there could be suppression based on ineffective counsel?
Again, two arguments. One is that it was effective assistance because there was a tactical reason for it. Secondly, do we even get into whether it was effective as counsel if he had the right to confer with counsel, but the right to effective counsel hadn't attached under Claudio?
Right.
And here I'm kind of stuck saying that the judge below and even the Fourth Department got the right result for the wrong answer, or not the wrong answer, but one right answer, and they ignored another right answer. And the situation here is where you have the defendant being questioned and the lawyer coming down to the trooper barracks to meet with the defendant and ultimately giving the statement. At the same time, they're putting together the violation of probation paperwork.
Right. Well, it's sort of questionable. It's all around the same time, right?
Yes, yes. And that paperwork lists a number of reasons why the defendants had violated probation, and it enumerates them. And in the enumerated reasons, it does not list this event. In a supplemental page that went with it,
refers to it, right?
Refers to it, or actually refers to the day before, but I think it refers to April 22nd, but I think they're talking about April 23rd, the day this happened, that he's being investigated for it. Now, does that bring in and link these cases enough to create the shield of a right to effective assistance of counsel, that is commencement of proceedings? I suggest not. I would refer you to People versus Stewart case that involved a person who had a parole warrant out for them when we spoke to them, and this court found that that questioning was proper. I think it's an 88 New York 2nd. And I think under the same theory, the judge could have and should have said, we're not going to even have to decide whether Attorney Savlov, the first attorney, was effective. But the judge went ahead and said he was effective, and I think that is there's a proper basis for that.
If he
as well.
was ineffective, could that be a basis for suppression under Claudio?
If you reach that he had the right at that point, yes.
Is this one of the, assuming that there is a right, is this one of those cases where it's very hard to determine effectiveness on direct appeal? Wouldn't they have to make a post-trial motion at which that you can examine whether this was a reasonable decision at the time?
If I understand your question, Judge, I think the proper way to litigate it would be at a Huntley hearing with all the issues raised at that time. And we didn't actually have the hearing. We had a stipulation here of the facts. But the judge made a pretrial decision, and the appellate division affirmed that. And
you said the record's adequate.
yes.
Stipulation really isn't that strong, right? I mean,
It's not that thorough.
I mean, you would think there's a better way to resolve this other than looking at that stipulation.
Well, that was what they decided to do. They could have had evidentiary hearing and called the witnesses. And
Yeah, but
it
wasn't
would have been more.
necessarily in the interest of the defendant to have the stipulation, right?
Well, that's what they agreed to. And after it was stipulated to.
Counsel, you want to do causation, which is the first issue that your adversary raised?
By last minute, I do. I don't think that DaCosta is really distinguishable from the situation. And to make a gravity of crime distinction, I don't think would be appropriate.
What about the judgment issue that your adversary raises, that the trooper exercised very bad judgment in pursuing this and, really contributed greatly to this?
Well, we all wish he didn't continue the chase. It's tragic. But we don't know why he did. We know he was chasing someone who kept speeding away. We can, I think, conclude from this that he probably perceived that this was started out as speeding, escalated to reckless driving, and who knows what else, and who knows what danger was posed to the other people on the road. If he had discontinued the chase a mile into this 7-mile chase, and this motorcyclist causes a multi-fatal case down the road, then the trooper's going to be criticized. And, again, we can't ask him. We'll never know.
Okay.
But I say that under Matos, under DaCosta, this defendant put it in motion, was foreseeable, and to the extent that the issues are preserved, You should affirm and
Okay, counsel.
find conviction. Thank you.
Thank you. Counsel? Counsel, you want to discuss ineffective counsel, which was the third issue that we discussed with your adversary?
I'd say that again, please.
You want to discuss the ineffective counsel issue?
Yeah, 2 points on that.
Sure.
First, it's clear here, I believe, that the judge did not exercise his discretion. He at the very first meeting, he told Mr. Modesto, I disagree with you. This is not a waivable possible potential conflict. This is an absolute conflict. That's at the very first colloquy that took place with the court. And then what is even more revealing is that on the very day that Ms. Campbell, appointed by the court to discuss the situation with the defendant, reporting to the court that, yes, he did understood it, yes, he does want to waive, and so on that very day, immediately after she had made her report, and the defendant on the record said, yes, I agree with that report, the judge pulled out his already completed 3 or 4 page, single-spaced
Had been
decision.
prepared in advance, right?
And so it's clear that he'd made up his mind from the very beginning. This is an absolute, non-waivable conflict. That's it. And what he was really doing is going through the motions. If I just may say one thing, if this court does conclude that the argument on criminal negligence is not preserved, and I certainly hope that the court will not rely on the one-sentence application of People against Gray, which doesn't apply. If the court hears the argument on criminal negligence, this decision cannot stand under People against Cabrera. And so what this case amounts to, if the court does not hear the arguments in full and let the criminal negligence argument come up with the causation, it amounts to a cruel irony, because what has happened here as a result of the judge's misguided and undoubtedly well-meaning effort to try to protect the defendant from this possible conflict, put in place, took away the lawyer he wanted and put in place Mr. Piemonte, the substitute lawyer that he didn't want, who made all of the errors. So as a result, not only of failing to preserve, but also failing to object twice to the but-for charge in causation, but for the original decision of the court, which led to Mr. Piemonte's substitution, this defendant would not be facing the completion of a 7-year term, would not have to go through life having been convicted of a felony for causing the death of a state trooper.
Okay. Thank you, counsel.
Thank you, Your Honor.
Thank you both. Appreciate it.